Keep her and her suitcase away. Okay, we're going to talk about a few of the latest motions in today's video. Hello Sofa Squad and welcome back to the sofa. The sofa's back here, and as you see, one of the little babies is here with us. This would be Luke Connor. Now I was going to hold him, but he's sleeping so well in his little crate. We have been doing crate training with each of them, and so he's sleeping in his crate. He's doing very good, but he's just here with me right now. So the other one is being babysat by Matt. So I was like, I'm not going to leave him out there while I record, but I'm also not going to pick him up unless he starts, doing little puppy stuff. Then I'll bring him out. So that being said, today we are going back down the Suitcase Sarah rabbit hole. Now I'm filming this on October 1st. It's been a very crazy weekend with work and just a bunch of stuff going on, right? And so I haven't been able to really do anything. So that being said, I got so many things from out yesterday on this motion about the state filing this order against Sarah. Literally I was like, I'm afraid to even go look at it, okay? So what I did is I went to the myorangeclerk.com. I downloaded the motions I want to talk about that are currently up right now. This could change in an hour, right? I really didn't even read it. I started skimming through it and got the gist of it, but I was like, I just want to wait till I come to the video so that we can go through it together. So that being said, you're probably going to see this on October 2nd, which I believe there is a hearing today. I could be wrong. They'll probably be going over this stuff. So there could be a resolution to it is what I'm saying. Now, if you're unfamiliar with this, we've been following the Sarah Boone case. She is in jail. She's incarcerated. She's been charged with taking the life of her boyfriend George by getting him into a suitcase and letting him succumb to suffocation. The trial is coming up on October 7th. She has a new lawyer. They've been throwing anything they can, trying to do what you do when you have a defense attorney and you don't want to get in trouble, right? And so that's all that is. Before we go any further, please know I am not a lawyer. I'm not a therapist. I'm not a cop. I'm not any of that fancy credential stuff, okay? The only credentials we got up in here are the sofa and some sass. And well, I guess, the little cheerleading crew over here, right? So these are just my opinions. They're based on very public information, and I'm not credentialed. So if I say things like, oh, I think they're a narcissist, whatever, it's just my opinion, okay? That being said, on the note of narcissism, let's start talking about Sarah's latest motions. Okay. Now, what I want to do first is look at this first motion, and this is, you'll see it on the screen here. You can read along with me or just listen to me go through it. It says, State Memorandum regarding defendant's statement to Deputy Kayla Rodriguez and Detectives Copsel and Lowen on February 24th, 2020. This is going to be in major relation to the interview, okay? The interview, right? And so that's what this is in relation to. Let's get into it. So number one, Deputy Rodriguez, in response to a 911 call made by defendant shortly before 1 p.m. on February 24th, 2020, responded to the defendant's residence. Deputy Rodriguez activated her body-worn camera while still en route to the defendant's residence. All interactions with the defendant were recorded. There are 3 recordings. One's at 1:08 p.m. and lasts 13.32. The next is at 1:22 p.m. It lasts 4.56. And the final one starts at 1:30 and lasts until 5:30. At no time was the defendant in anything that resembles custody for Miranda purposes. Okay, now remember, this is Sarah trying to get the Miranda rights stuff and all this thrown out in these interviews. They cite the case law. The Ramirez case outlines the famous 4-factor test, the manner in which police summon the suspect for questioning, the purpose, place, and manner of the interrogation, the extent to which the suspect is confronted with evidence of his or her guilt, and D, whether the suspect is informed that he or she is free to leave the place of questioning. So number 5, while Rodriguez would not let the defendant enter the crime scene, the defendant's home, to retrieve a soda or cigarettes, the defendant was not in custody. 6, the deputy was a first responder trying to gather preliminary information about what might have happened. The defendant was spoken to on her porch and sidewalk area just outside of her home. She was not confronted with any evidence because at that time there was nothing to confront her with. All this is very public. We've all seen this if you've been following this with me, right? The defendant was informed she was not free to leave the area due to the investigation, but the restraint on her freedom of movement never resembled custodial arrest. 7. Just under 4 hours later, she was interviewed by Detective Counsel and Lowen inside an unmarked car on scene. Although under both Ramirez and Rincon, this is not custody for purposes of Miranda. She was given her Miranda warnings. For the reasons outlined in the state's response to the defendant's motion to suppress statements at OCSO, the Miranda warnings were not defective, and her waiver of her Miranda rights was voluntary, and her statement was voluntary. 9. Any motion to suppress on these statements would not be granted. And then the last thing is just going into, they provided the copies and whatnot. Now, again, this isn't trying to say that the Miranda rights were violated and they didn't read the last one of it, and so this, that, and the other, and blah, 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 blah. One thing that comes to my mind with this, and again, just sofa speculation and viewpoint here. Again, if you've watched the body cam footage and all this type of stuff where she's panicking and, oh my God, this, da, 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 da. Number 1 is in the afternoon, okay, at this point, right? Number 2. Imagine yourself in a normal situation, okay, where you honestly, some accident happened in your home or whatever, okay? Cops are there. We want to, this is what we're doing. Your purpose is to find out what happened, either get your loved one, person, whatever, help, or if it's obvious they're gone, you're wanting to help the cops and do this and that. So Sarah coming back, and again, maybe she legitimately thought at that time, I didn't do anything wrong, even though things got out of hand. This is me pretending to be her in her thoughts. It was unintentional. It was this, it was that. So her trying to argue about, I was in custody, I was this, I was that. I'm sitting here thinking this. I'm like, girl, no normal person would be dissecting this like this at this point. Because if there was truly an accident that had happened, this wouldn't be a question. You know what I'm saying? Again, when the cops arrive on scene, they don't know what happened, okay? They have no idea. They're figuring out just like this says. So all they know is they're showing up. Here's Sarah, who there's clearly behavioral issues going on with. She's probably detoxing, coming down from the night before. They're just trying to gather information. And again, as they're gathering this stuff, things don't sound right, including the way Sarah recounts the story. When it's, we were playing hide and seek, you show up on scene. Forget that. You show up to your friend's house. Imagine going to your friend's house as an adult, okay? And they're like, hey, how was your day? What'd y'all do? Me and my boo were playing hide and go seek after we painted and sang songs. He hid in the suitcase. Isn't that funny? You would probably be like, huh? Unless you were going there for some kind of psychedelic trip or something, then that might be like, okay, cool, I got it, right? Like maybe you went on a journey or something. But some kind of like just normal rational, you'd be like, are you okay? Like what is this, some kind of therapy, couples therapy? What you talking about? So this is going to be the first red flag to them, okay? So again, that's just the main thing that comes to my mind is I'm just like, if this was truly an accident, this wouldn't even be an issue. None of this stuff would be going on, okay? Or a worry to have about it because it would have already been resolved. It would have been like, oh, you know what? We didn't find a video of you berating the victim while he begged for his life in the suitcase, okay? Like that wouldn't have even happened if it was truly an accident. Let's go on to the next document. Now we're going to go on to one from the defense, and this is to amend motion to suppress defendant statements at OCSO. And we're just going to jump to number 1. The defendant, Sarah Boone, is charged by way of information with a single count of second-degree M. 2. On or about February 24th, defendant calls 911 in response to finding her boyfriend, Jorge Torres, deceased. 3. Deputy Rodriguez of the Orange County Sheriff's Office arrives on scene, body cam activated. Upon arrival, Rodriguez spoke to the defendant and realized a death had occurred. Rodriguez advised her superiors and secured the scene. Number 4, sometime later, homicide investigators Connolly, aka Chelsea Counsel, and Scott Lowen arrived. These 2 investigators would ultimately be responsible for this homicide investigation and were involved in the interrogation of the defendant at OCSO the next day. The defendant was ordered to remain on scene while the OCSO conducted their investigation. As ordered, the defendant stayed outside of her apartment for several hours until the investigation was completed. Now notice the wording here, as ordered, right? Again, think of anything, especially if you're in the business or whatever you want to call it, this is standard protocol. A crime scene, as something has occurred, right? they're going to want you out of there, especially when they hear the little parameters of it. Anyways, let's keep going. So, number 6. At some point, the defendant was told to get into an unmarked vehicle with Detective Kopsel and Lowen. Once inside, Kopsel recorded an interrogation with the defendant after partially reading her Miranda rights, omitting the final question. The defendant was advised this recorded interrogation was routine protocol and official procedure for any death investigation. Now, I don't know if that's true or not, if that is standard protocol. I personally would think it would be. If somebody, especially in these circumstances, died in a suitcase in your place, that they would want to get a statement from you. I mean, come on, right? Like, that just seems like part of the procedure here, okay? But I could be wrong. Let's keep going. Number 7, during the investigation, Kopsel asked to see the defendant's phone. The defendant told the detective her phone was on the kitchen counter in her apartment. The detective brought the defendant her phone and instructed the defendant to unlock it. The defendant complied with the demands of the lead investigator. Notice, demanded, complied, demands, all these words, right? 8. Detective Kopsel had the defendant's phone for a period of time. She came back and told the defendant that she was taking her phone. Kopsel asked the defendant to sign a form releasing it to the OCSO for further investigation. The defendant acquiesced to the authority and signed the form. Again, these words, these verbiage. 9. Defendant was told that one of the detectives would return her phone to defendant at her apartment in Winter Park the next day. 10. Later that evening, defendant moved to her ex-husband's home, Brian Boone, for the night using her ex-husband's phone. The defendant called lead detective Chelsea Kopsel on her cell phone to express concern that Kopsel was not being truthful about law enforcement motives as it relates to the defendant. Let me finish and I'll tell you why I chuckled. The defendant told the detective she believed they were trying to trick her and being sneaky about something. So just that part right there, okay, to me is like guilty conscience. Like, why, literally, why would you call and say that? Number 1, especially if you did do something, right? That's like the last thing you want to do. Imagine Jeffrey Dahmer calling up in some scenario. Hey, y'all don't think I'm over here eating people, do you? I just want to make sure. Because I feel like y'all are trying to get tricky and say that I'm over here eating people. You know what I'm saying? It's like, that's probably like a big way to raise red flags there, okay? But then especially if it's an accident and like pretend that this truly was 100%. Even if you thought that, to call them out on that is just making things 10 times worse. Okay, let's go on down to number 11. Okay, so the detective assured the defendant that they were not trying to trick or implicate her, but the following day the defendant needed to drive to Orange County Sheriff's Office to get her phone. The detective explained the reason for the change in plans was because she was pregnant, she didn't feel good. 12. The next day, the 25th, the defendant arrived at the OCSO to retrieve her phone and had questions about this tragic event. Remember when she walked in there and was like, I've got a list, right? She was like, I've got this list. Now remember, at this point, we're going to rewatch this interrogation. I have a video of it. We've actually rewatched it a while ago, but as trial's approaching, sometime this week, we will rewatch it, okay? Just to get back on the same page or whatever, and because it's literally just true crime classic, it's very fascinating on many levels. But when she goes in there and slaps that list down, these detectives have already looked and seen this stuff on her phone, right? It's very damning evidence. So that's why they're like, yeah, we'll get to your little questions. I mean, they know, okay? So let's keep going. Upon information and belief, a judge had signed a search warrant for the defendant's phone just 9 minutes before she arrived at the sheriff's department. While still under the impression that she was retrieving her phone, Detective Lowen led the defendant upstairs into an interrogation room. Lowen wore his firearm on his waist during the entire event. I guess they're trying to make it sound like he was intimidating her. A custodial interrogation ensued. Immediately after the interrogation, the defendant was formally arrested and charged with the offense above. 14. This approximate 2-hour interrogation was recorded. 15. The initial dialogue between Kopsel and the defendant goes like this. Detective, I'm going to have to sit you in the green chair. Detective, appreciate you coming in. Sarah Boone,
yes, ma'am, and I want to ask about these, whenever you have a moment.
Referring to her written notes with questions. Detective, sure. Detective, so obviously he received his autopsy. Detective, so I'm going to read you your rights again because we have to talk about that. Detective, and we're not done talking about the incident. Detective, we just have to do it. Sarah Boone,
just like we did yesterday? Normal protocol?
Detective says, just like we did yesterday. Detective, remember I read you your rights. The rights. Detective, yeah, it's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you, okay? Detective, so you have the right to remain silent. Anything you say may be used against you in court. You have a right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one, one can be provided to you for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me? Sarah Boone says, nope. And do you understand what I just read to you? Yes. Detective, perfect. Okay. So, this morning we went to his autopsy and we were informed of some injuries he had by the doctor. Defendant, where? Detective, so he's got scratch marks to his back. Now they cut it off here right there because that's where Sarah's going to go. Oh, I know what that's from. We got frisky in between watching movie trailers, singing in the suitcase. Okay, I'm just going to be honest. Right, I'm just like, what? Okay, 100% we're watching this again. Now, before we go any further, this is what I'm talking about with this right here, okay? We're going to go off on a little side journey here, a little sofa sidebar, okay? All the stuff that the lawyer is bringing up, and again, I think personally he is just doing what Sarah says. She says all these things. I understand. No one threatened me. All this type of stuff. Leaving the last thing off doesn't really matter to me at this point. But again, who am I, right? Nobody but, somebody with a sofa size, a camera, and some, personality disorders. Let's just be honest, okay? But to me, this doesn't... I'm like, okay, what are you trying to say? So the vibe that I'm getting, I'm like, either this attorney is just completely off the mark on some things, or he is 100% just going down Sarah's list, even if it doesn't make sense, even if it doesn't do this, because he knows he has to if he wants to work on her case, right? Okay, let's keep going. The interrogation continued for approximately 2 hours. At the end, while still in an interrogation room, defendant was placed in handcuffs and arrested. That was a glorious moment, wasn't it? Like the utter surprise on her. Unintentional! Right? Okay, 17. The detective read the defendant her Miranda rights directly from the printed card of the OCSO. The detective omitted the final question printed on the standardized Miranda card of the OCSO office. The detective omitted the same Miranda rights question that she omitted the day before. The official Miranda question rights is, having these rights in mind, do you wish to talk to us now? Now, again, I understand this, and again, law is law, and whatever upholds this, but the other questions where it's like, we can get you a lawyer, do you want that? No. You know what I'm saying? Like, it's almost like it covered this stuff. I get you want to dot your I's and cross your T's and uncover every stone 100%. Like I say, any of us would want the defense attorney picking this apart. 100% can respect that, but I just don't see it holding water. Okay, so number 20. The defense is yet to receive a true and accurate copy of the Miranda rights card from the OCSO. Upon information and belief, it would look something like this. Now, they just do the card off there, okay? Based on all the circumstances surrounding the interrogation, the defendant's statement was coerced, not freely and voluntarily given. The defendant not freely and knowingly waived her rights under Miranda. As such, the entire 2-hour interrogation should be suppressed. Now it just goes on to do the little last stuff they do in these pages. It's from James Owens. Again, do I think that they'll do it? No. Do I know anything about this stuff legally? No, right? So this is just simply opinions. She did not act like she was being coerced. She did not act any certain way in there. Again, from my perspective, she was all too eager to talk to them. Now, at the end of the day, they can't help what they found on the thing. And the more they found, this is what I would have done if I was Sarah at a certain point. Now, I get when you're in this and cops have, yes, there is such a thing as false confessions, right? And coercion, 100%. I'm not someone who's going to be blind to be like, a cop would never do that. We've seen this take place, right? For those of us who really follow many cases. I don't think it's the case in this one, though. That's just my feeling. So at a certain point, Sarah should have been like, you know what? I don't want to say anything else. I don't like this feeling y'all are giving me. I want a lawyer. Am I free to leave? And at that point, they could have been like, no, we're placing you under arrest or whatever. But she was going to talk her way out of it in her mind, is my opinion. She, from the get-go, has wanted to talk her way out of this. And she looks like she's going to possibly get her chance to. Now, let's get to the wham-a-bam, thank you ma'am motion of the day, and that would be the state's request for a protective order. Now at the top it says, cometh and noweth, theeth, stateth, of florereth. And it just goes into that, so we'll jump on to number 1. The defendant in her third amended witness list has listed the following people as witnesses: the custodian of records, Orange County Office of State Attorney, domestic violence supervisor for the Office of the State Attorney, victim advocate supervisor for the Office of the State Attorney, misdemeanor supervisor for the Office of the State Attorney. The state requests a protective order under the Florida Rule of Criminal Procedure because anything these witnesses could say about the defendant and the descendant would be protected by the work product privilege, Florida Rule of Criminal Procedure. If the defendant wants public records from the state attorney's office, she should do what everyone else has to do: file a public records request. Subjecting prosecutors and their staff to this type of discovery of their investigations will require disclosure of work product and seriously impede criminal prosecutions, and it lists case law. We believe the trial court was right the first time in denying the pretrial defense efforts to subpoena the 2 state attorneys and inquire into oral communications, sworn or otherwise, between them and a state witness. The oral and unrecorded statements of witnesses to a state attorney are privileged as work product and not subject to discovery. It lists case law. Opinion work product involves a lawyer's impressions, conclusions, opinion, and theories of her client case. Opinion work product is an absolute or nearly absolute privilege, and it cites case law. Number 7, fact work product concerns what the attorney did and what she learned in her role as attorney. As the name suggests, fact work product is factual information which pertains to this client's case, prepared or gathered in connection therewith. Cites the thing. 8. The fact work product is discoverable only if the parties seeking this work product show the court, number 1, the need for this fact work product to prepare a party's case, and 2, that without undue hardship, the party is unable to obtain the substantial equivalent of this fact work product by other means. Thus, need and hardship elements must be alleged in the motion to compel and establish to the court's satisfaction at an adversarial hearing. Number 9. The state is at a loss for what non-privileged testimony any of the people listed above could provide in this case. Therefore, the state is requesting the court to enter a protective order to prevent any employee of the state attorney's office from being a witness in this case. It goes into sign the things here, and William Robert J. signs it. Okay, y'all. Let's check on the little puppy. Yeah, even that put him to sleep there, right? Yeah, I mean, let's just be honest here. Okay. I'm a little bit speechless. Now, also I'll say this, fascinating what they're doing. From a legal perspective, okay, these are, well, let me just say this, let me preface it. 2 things that absolutely fascinate me with true crime, from like, say, a technical point of view, is the psychology of it for both victims, their ability to overcome, go on with life, that type of thing. Obviously, like the forensic psychology of the people who commit the crimes, and then also the legal aspect of it. So this kind of stuff right here where I'm like, you know what, this is really interesting that they're trying to compel these people, and also very interesting that they're having to ask for a protective order. This is crazy. Again, with what they're saying up front, it almost sounds like they're trying to, like, where it's like file a public records thing. I am guessing on a lot of this type stuff, she is going to 100% want to go back through all these incidents, all these records, and try and prove how horribly abusive he was. She is ignoring the fact that she has a line of other victims, cough, cough, ex-husband Brian Boone, who are going to get up there and speak to a very not nice version of her. From my understanding, I could be wrong on that. Consider it sofa speculation. So that kind of testimony, imagine your ex getting up on the stand talking about, yeah, you know, she was getting crocked every night, yelling at her kid, hitting me, punching me, throwing suitcases around the damn house, you know, the whole 9 yards, versus these things that come up that we see with the blemishes between her and George. many of which we have body cam footage to see. And the body cam footage, it's clear she's either making stuff up or is so blackout drunk she doesn't even know what she's talking about. It's insane, right? No one, just like the state attorney has said early in one of the earlier hearings, no one is denying there's issues from both George and Sarah. No one's saying it was a peachy rosy relationship. They are aware of these things. However, from the SOFA viewpoint, and especially from what we hear so far on the legal standpoint, it doesn't look like there's enough there for these claims. And again, even if those things are there, when you isolate to this incident, the footage, again, the interview, unless she can get it suppressed, but I don't think she will, but just the footage alone of what she's saying and doing to George when he's in the suitcase, before you get into testimony from other people, it's not looking good. But this is the downfall of Sarah and people like her that we see in these cases where they are convinced. You can't tell them otherwise. Number one, that they're right. Number two, that they are going to get up there and talk their way out of this. It absolutely fascinates me to see. And insanely frustrates me too, right? So, those are the three things we're covering today. I just wanted to go over there, talk about get your opinions, that type of thing. Again, there could be a hearing on all these later today, and so we'll get maybe some kind of answer to it. We shall see. So, if you're still watching, well, I do appreciate you. And if you could drop some little sofas off in the comment section for myself, for our little sleeping Luke Connor, for Roscoe and Spirit, and the rest of the Sofa Squad. And until we all meander down to your comment section and hang out and talk about this, we'll see y'all soon. I just wanted to say thank you again for watching the whole video, and also thank you for being part of the Sofa Squad. Special thanks to all the Patreon members, channel members from both of my channels, everybody who likes, shares, subscribes, comments in the comment sections. It helps the channel out so much. Now, don't forget, I do have that other channel, the podcast channel. That's where we go live, we hang out, we talk. We have kind of sort of a schedule, but just be sure and check it out. I'll put it up here on the screen. Also, if you're looking for merch, be sure to check out my Teespring store. I'll put that up here. And then, like I said in the beginning of the video, if you want to follow me and Roscoe on the Instagram, go on, check it out. It's right here on the screen again. But once again, thank you very much. I really appreciate you being part of the Sofa Squad, and I'll see you in the next video.